Let me welcome you to our 2017 Constitution Day. I'm Bud Bazelak, the provost here at Case Western Reserve University. It's an exciting day. This is, I think, my 10th time I've been at Constitution Day, and I learn a lot every time we have these sessions. I appreciate everybody who's here. I know I've got to keep this timely, and I'll just really begin by just thanking everybody, thanking our guest speakers. Look forward to hearing from you. Thank you for the student organizing committee, all the hard work you put in. You know, some of you involved with this event multiple years, and I look forward to hearing the questions that you're going to bring. Certainly the faculty advisors, in particular Professor Lucker and Tartikoff, for all the work you've done in preparing the students and preparing for this event. This is really, you know, in terms of freedom of expression on college campuses, a very timely conversation, a very timely topic today. It seems like every morning when I open up my email, I get some announcement from the campus. Today was University of Chicago announcing their freedom of expression day or event or week. And this is obviously a very critical issue today. You know, it's interesting, over the years, the topics we've had at the Constitution Day events here always are very timely. You know, they connect to something that's going on either across campuses or across certainly the country. This one, I think, of all the 10 that I've been involved in, is probably the most timely. It's a complex issue. It's a challenging issue. I think as we're here today to learn, I mean, it will be, the key to making it work on this critical First Amendment topic is communication, understanding, and I think amongst all of us, and that's why we're really here today to do that. So with that, I will introduce our MC, Kelsey Holmberg, who's, again, this is your third year doing this, so welcome to that.
Thank you, Provost Bazelak. We appreciate your presence and support at this event over your many years at Case Western Reserve University. Good afternoon, distinguished guests, faculty, students, and friends. I am Kelsey Holmberg, and I am the Mistress of Ceremonies for today's event. The purpose of today's event is to celebrate the 230th anniversary of our founding charter, the United States Constitution. It is an honor to welcome Ms. Susan Kruth, a senior program officer from the Foundation for Individual Rights in Education, known by its acronym FIRE. FIRE is a leading nonprofit that defends and sustains individual rights at America's colleges and universities. We also welcome Professor Reginald O. Professor O is a renowned speaker on legal issues in education and a professor of law at Cleveland Marshall College of Law at Cleveland State University. The Constitution Day Student Committee is grateful that you have accepted our invitation to speak and to answer questions from our panelists and audience. Universities that foster reasoned and thoughtful debate are vital to a thriving society. This forum will address the extent to which speech can or should be regulated on a college campus. Can universities balance freedom of expression and the need for campus safety? What, if any, restrictions can be placed on student expression at a private institution? We look forward to hearing the perspectives that the two speakers will present according to their understanding of the United States Constitution. Now allow me to introduce our panelists. Ms. Coco Itakabe, Mr. Santiago Reyes, Ms. Amanda Spangler. Finally, please join me in welcoming the moderator for today's forum, Mr. Jacob Sandstrom.
Thank you. Ladies and gentlemen, in 1791, Congress amended the Constitution to safeguard essential freedoms. Recognizing the realities of human nature, our founders put the freedoms to worship, speak, publish, assemble, and petition at the heart of the First Amendment. College campuses have long been havens for free expression, allowing students to pursue wisdom by exchanging facts and ideas. But recently, colleges find themselves on the front lines of unrest and discord. In wake of the violence at Middlebury College and UC Berkeley in the past year, Is it necessary to ban controversial speakers from campus? 5 states say no. North Carolina, Tennessee, Utah, and Virginia have passed laws to prevent administrators from canceling speakers invited by students or faculty. The laws require universities to remain neutral in public controversies and to sanction students who interfere with the free speech rights of others. Moreover, the violence in Charlottesville has prompted public outcry and a new discussion on free expression's role on campus. Civil discourse is in a grave state. A recent clash at Berkeley resulted in the near-fatal beating of a protester. Innocent demonstrators were injured and killed when that car plowed through the crowd in Charlottesville. Given these realities, are there sensible limits to free speech that colleges should impose? Now, before we begin, please take a moment to check your cell phones. Professor O and Ms. Kruth, you will each have 10 minutes for your opening statements. Ms. Kruth, the floor is yours.
Thank you. Thank you to Case Western and to the Constitution Day Student Committee for having me here today. I wasn't sure if it was going to be harder to do a panel on free speech in light of the tragedy in Charlottesville and other instances where protests have turned into violence and vandalism on campus. But legally, the rules are the same as they've been for decades, and practically speaking, the reasons why we have such stringent protections for freedom of expression are more relevant than they've ever been. I want to first make sure we're all on the same page as far as what the First Amendment protects, broadly speaking, and then I'll talk a little bit about why we don't punish more speech and what we can do instead of punishing speech. The vast majority of speech is protected by the First Amendment. There are just a handful of categories of speech that are unprotected, things like true threats, obscenity, incitement to imminent lawless action. Those are not protected, but it's important to remember that these each have legal definitions that are much narrower than the way that we use these words colloquially speaking a lot of the time. Now, you'll hear people argue that there's a line between hate speech and free speech. In the US, there isn't. There's no legal definition of hate speech because, in the United States at least, because it's not one of the unprotected categories of speech like true threats and incitement. And some of what somebody might call hate speech might rise to the level of true threats or incitement, and in that case it would be unprotected, but most of it does not rise to that level, and so it's still protected even if it's offensive or hateful. And part of why we don't prohibit hate speech broadly is because people wildly disagree about what would qualify as hate speech. Just the other day, for example, Donald Trump Jr. tweeted, if it's hate speech to call someone by the wrong pronoun, then it should be hate speech for somebody to burn the flag. Or for another example, maybe you think that the Westboro Baptist Church's signs that say God hates fags are hate speech, but maybe somebody else thinks that the way that you talk about the Westboro Baptist Church is hate speech too. And if Americans can't come close to agreeing what qualifies as hate speech among ourselves, then it's never going to be safe for us to trust the government or some higher authority to make that decision and to censor and punish people accordingly. So in most cases, with the vast majority of speech, you cannot be punished by the government just for what you're saying or censored. And since public colleges and universities are instrumentalities of the government, on public college campuses, you have pretty much the same free speech rights that you have just out and about in the real world. The school might have measures in place just to make sure that the functioning of the university can continue uninterrupted, but it can't punish you for saying something that it doesn't like based on viewpoint, or for just handing out literature peacefully on the quad, although depressingly, a lot of colleges have tried to do this anyway, even though it's prohibited under the Constitution. I'm sure a lot of you guys are thinking right now, well, Case Western is a private school. And private schools are not bound by the First Amendment. If they want to, they can prohibit certain types of speech, even based on viewpoint. But what they can't do is promise students and professors the same freedom of expression that they would have at a public school, and then turn around and censor students or punish them for their viewpoints. A few private colleges are really upfront about the fact that they prioritize other values like religion or civility over freedom of expression, and that's fine. For example, a lot of, BYU, I think Vassar does this, but the vast majority of private colleges and universities around the country do promise their students and professors freedom of expression, and Case Western is one of those private colleges that does that. So, for example, Case Western says in its policies, universities seek to preserve, disseminate, and advance knowledge. As CWRU, as elsewhere, we recognize that to fulfill these purposes requires a norm of expected conduct shared by all in the university community, governed by truthfulness, openness to new ideas, and consideration for the individual rights of others, including the right to hold and express opinions different from our own. So a prospective student reading this could reasonably expect to be able to speak his or her mind on campus once they get here, similarly to how they would be able to express themselves on a public college campus. And Case Western enjoys all the benefits of applicants believing this and being attracted to this campus. But the university also has a policy, for example, prohibiting posting offensive language. And that could be almost anything depending on who's looking at it, because of course we're all offended by different things. And it also has a policy saying that university facilities can't be used to advocate for partisan positions. Now, most private colleges also have these sorts of inconsistent policies where they promise freedom of expression, but then on the other hand, they prohibit certain types of expression. That's normal, but it shouldn't be. It's really not fair to students, and especially prospective students who are trying to make an educated decision about where they want to go to college. So I hope that those of you who care about freedom of expression on campus will pressure your administrators to really bring all of the school's policies in line with the provision that I read out loud just now about the right to express different opinions. But I know that there's also a lot of disagreement about just how far that right should go. And there's no denying that it's really hard to hear some speech, especially the sort of hateful and bigoted speech that's been in the news a lot lately. So we have to remember that the potential ramifications for punishing this speech or censoring it are really going to be much worse than the burden of us just fighting speech we don't like with our own speech. As illustrated by the Trump Jr. tweet that I mentioned before, it really takes no time at all before any justification that we use to censor speech we don't like gets flipped around and used to censor us. And especially if you believe right now that we have to be fighting systemic racism and sexism and bigotry, as I suspect a lot of you do believe, why would you feel comfortable giving censorship authority to the people who are in power right now? Here's another thing. I'm Jewish by blood, although the last time I really practiced was at my bat mitzvah when I was small. But during my adult years, my dad he's really tried to explain to me how pervasive anti-Semitism is. And to be honest, I didn't really believe him for a while. I didn't see it myself. And so I would say to him, Dad, I get that there's always going to be a couple stragglers and some people who, don't get it. But in the US, I don't think that people really hate Jews anymore as like a thing. And I mean, I still would like to believe that most people do not hate Jews, but seeing hordes of people chanting, "Jews will not replace us," in 2017 at a place I had lived for 4 years was staggering and really eye-opening. And if nothing else, these open expressions of what we call hate speech at least serve that purpose, which is that they make it much harder to deny all of these problems that minorities and marginalized communities have been trying to point out for ages. And of course, you can't solve problems unless you acknowledge them and see them. So that said, obviously, several recent demonstrations have crossed a line, a legal and moral line, between pure speech and conduct. And it doesn't matter what your viewpoint is, vandalism and violence are not an acceptable part of a debate either on campus or elsewhere. So, what can schools do? They aren't ever really happy to hear it, but to a large extent, they really have to bear the burden of doing whatever it takes to allow controversial speech and also keep students safe. So if that means that they have to pay several thousand dollars in order to have security come on campus, then that's up to them. Schools also can bring in law enforcement in response to true threats, and they can respond to harassment as defined by law, but they can't shut events down just based on an amorphous suspicion that something might happen. And that's the price that we pay in order to know that our events and our speech is not going to be shut down just because someone who disagrees with us is threatening to cause a disruption. But at the same time, schools can do a lot to counter speech that they don't like without running afoul of the First Amendment. They can publicly disapprove of this hateful, bigoted speech as long as they make clear that students will not be punished for disagreeing with them. And they don't have to wait until something tragic happens. They can have programming about diversity and civil rights. And a lot of schools really do walk this line very well. So schools don't have to stay neutral. They can speak out. They just can't demand that students align themselves with their institutional view.
And you'll have more time to address some of those points during the question period. Professor O?
Okay. First, I want to thank the organizers of this event for inviting me to speak here. And as the provost was saying, this couldn't be timelier than today. My thesis is this: that of course the right to free speech is important. The schools, universities, colleges depend on free speech to function and promote its educational goals. What I want to argue, though, is that the right to free speech is and has never been absolute. There always have been categories, exceptions to free speech, and that colleges and universities, private or public, should be able to regulate low-value, dangerous, or harmful speech in order to provide for a safe, open, and inclusive learning community. And I'm going to focus on issues with respect to racial and gender inclusion, but it could apply to inclusion based on religion, sexual orientation, disability. Okay. Let me first provide a couple of, I know there's been in the news a lot of events that have occurred on campuses regarding hate speech. So I'm just give you a couple of examples of that. In 2012, University of California, San Diego, there were public display of nooses on campus by students, and students wearing Ku Klux style hoods on campus. And in addition to that, there was a frat party where students dressed, there was an invitation sent out that was racist and based on racial stereotypes, and students dressed up as stereotypes of African Americans. So that was University of California, San Diego. In 2015, at University of Oklahoma, they had a video of a fraternity got around, became public, and the main part of the video, they were chanting this: "There will never be a N-word at SAE," the frat. "You can hang him from a tree, but he'll never sign with me." Okay. I think we can all agree that's pretty abhorrent speech or conduct. And the question is, should schools be prohibited from doing something about it? Okay. Can they do nothing about this kind of speech because the right of free speech trumps the concerns raised, no matter how harmful and worthless the speech is in terms of its value? And I want to argue the answer is no, that schools can do something, and in many instances, they actually have to do something about it. Okay. Just to the first point, and as we agree, the First Amendment is not absolute. You do not have an absolute free speech right to say whatever you want at any time. Okay. There are categorical restrictions that says certain categories of speech, like obscenity, fighting words, are beyond protection. Okay. There are time, place, and manner restrictions on speech. And in the school context, the courts have held in both secondary and colleges that speech that's disruptive and affects the learning environment can be prohibited, and it's not protected speech. And it makes sense. Even obviously free speech is important on campus in order for people to learn, for students to learn, but education fundamentally requires restriction of speech. So for example, you're having a class, you're trying to teach literature. If a student starts talking about the football game, right, during classroom, you'd say that's not appropriate. That exceeds the limits. That kind of speech is not appropriate given the context of the learning environment, okay? And it's irrelevant, okay? So we need to understand that free speech is important in education context, but restricting free speech is also important, okay? And the court has talked about what are called things like obscenity, okay? Things that are considered low-value speech considered having very little social value, little merit. And let me give you an example of what the court has considered low-value speech, and it's very pertinent to what, the issues we're talking about, especially with regard to hate speech. In Virginia versus Black, the U.S. Supreme Court upheld a criminal statute which prohibited cross-burning, conveying a message of intimidation. Okay. The court upheld the criminal statute, and in doing so, they recounted the historical connection between cross-burning and racism and racial intimidation. Now, let's be clear here. The court, in saying this could be prohibited and criminally prohibited, wasn't saying it was conduct. They were saying because of the message it conveys. Okay, cross-burning is a form of symbolic speech because of its message and its intent to intimidate, that it's outside of First Amendment protections and can be prohibited. And this was a quote from the opinion, which talks about that certain kinds of speech with low value don't deserve protection. The court said this: the First Amendment permits restrictions upon the content of speech which are of such slight social value as a step to the truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. Okay, so the court is saying you can restrict speech because the society has determined it has no value, little value, counterproductive towards truth, towards protecting morality, and government are permitted to prohibit, restrict that kind of speech. Okay. Now, with that said, I want to suggest that colleges and universities have not only are they not barred from dealing with this kind of hate speech, but sometimes might have a legal and constitutional duty to protect, to regulate harmful speech to the extent it affects the learning environment. And I want to talk about, we talk about the First Amendment, but colleges and universities are also have to comply with several civil rights statutes. And I want to talk about Title IX and Title VI. Title VI of the Civil Rights Statute prohibits what's called a racially hostile educational environment. And Title IX of the Title IX prohibits hostile educational environment based on sexual harassment. Focusing on racial hostile educational environment, a student suffers from legal discrimination when he or she experiences, when a racial hostile educational environment exists, and it's, if the conduct speech is so severe and pervasive that the harassment interferes with or limits the ability of a student to participate or benefit from the educational program. Same thing with respect to hostile educational environment based on sexual harassment. If there's sexual harassment is so pervasive, it affects and limits and restricts the student's ability to learn, there's discrimination under these statutes. And the key part about this is that what constitutes a educationally or hostile educational environment? It's speech. Speech is the central thing that leads to these kinds of creations. So for example, just let me talk quickly about, I'm running out of time, but two cases. One case deals with the, it's in the employment context where a similar concept applies called the racial racially hostile work environment. And in a case called White versus BFI Waste Services, the court held that a racially hostile work environment existed based on speech expressed by the employee's supervisors. The African-American employees in that case were routinely referred to as boy, porch monkey, mighty Joe Young, and the N-word. And the court noted that the power of racial epithets to inflict real harm, and it said, far more than, regarding the N-word, far more than an offensive utterance, the N-word is pure anathema to African Americans. Perhaps no single act or word can more quickly alter the conditions of employment and create an abusive work environment than the use of an unambiguously racial epithet. In Monteiro versus Tempe Union High School, dealing with the high school situation, same students subject to racial slurs, and the court held speech alone was enough to create a racially hostile work environment, educational environment where students could not really learn and were denied equal education. So I think if we understand what kinds of laws that colleges and universities are beholden to, it's not just the First Amendment, but it's also these other competing legal regulations. And the schools it's a duty. The schools have a duty to ensure that the environment is conducive to learning and that it's inclusive. And speech can be counterproductive to it, and the state and schools should be able to and might be required to intervene and do something about it. Now, just a couple key points about the hostile educational environment claim. One is, how do you determine that? This is a question raised, which is, how do you know whether something is offensive or harmful? Okay. Well, from the case law regarding hostile work environment, the courts have said that you determine whether an environment is hostile based on the reasonable perspective of the victim. That if a reasonable minority or a reasonable woman in that situation might perceive the speech or conduct to be harassment, then that's the basis you would use. And I think that's a reasonable basis to use to determine whether an environment is hostile, okay, because it's an objective standard, but it takes into the considerations of the potential victims of hostile work or educational environment. Now, the last point I want to make is that with regards to ensuring that a hostile educational environment doesn't exist, okay, colleges and universities should not have to wait until a hostile environment comes into existence before it has to do something about it. Yes.
You just finish your point just briefly.
Okay.
Sorry,
yeah, I was going to say that colleges and schools and universities should be more proactive in making sure those don't come into being in the first place.
Okay, thank you. So now we will proceed with the questions from the panelists. Professor O and Ms. Kruth, you will have 5 minutes to address the question, whoever the question is addressed to. Then the other speaker will have 3 minutes to respond, and then the original speaker will have 2 minutes to rebut that response. And Mrs. Takati, would you like to proceed?
Thank you, Mr. Sandstrom. In 2017, Michigan State University banned personal whiteboards on college dorm doors due to a string of anonymous, hateful messages. Some have written that college is supposed to be civil society on training wheels. Others would argue that speech bans and posting restrictions constitute unnecessary hand-holding. My question is, Professor O, are universities justified in limiting certain modes of expressions, such as personal whiteboard use?
What I would say is that, I'm not going to take all 5 minutes, but with respect to personal whiteboard use, it's not based on content. They're not restricting you based on what you are saying, right? It's based on saying you can't use a particular way, a mode of restricting or of expressing yourself. And given what I just mentioned, if there's been a concern, an issue with kind of racially or sexually harassing speech, then that may be one way what schools might do to try to confront those kinds of issues. And that's kind of what I was alluding to at the end, at the end of what I was saying, that schools should be proactive in dealing with this, not wait until it occurs to act on that end. Okay, and it may seem inconvenient. It might seem trivial. It might seem like no big deal. Why are you banning personal whiteboards, use of whiteboards? But there are other concerns and values involved. Okay, and the part that I think that makes it, it may be an inconvenience, but it makes it not so endangering of free speech values because it does lack any content value, or it's not really focusing on the content of what you're speaking, what people are saying.
Ms. Kruth?
Thanks. I agree that banning whiteboards on its face looks content neutral, but I think it's important for students who see these sorts of changes in response to specific content or viewpoints being posted. I think it's important for them to keep an eye out. I think it's sort of a red flag when schools do start shutting down certain forms, when it's clearly in response to certain viewpoints being expressed. I also think, in response to what you said about schools sort of being, or colleges sort of being training wheels for the real world, I think to the extent that's true, it should mean that students, I mean, they're mostly adults by the time they get to college, and so they should really be getting used to the harsh realities of the real world, and sometimes that means hearing things that make them extremely uncomfortable. I agree with a lot of what Professor O said about harassment. Obviously, there are legal obligations to respond to allegations of harassment, but it's very important to make sure that whatever speech is involved rises to the legal definition of harassment and isn't just a comment that somebody finds offensive or uncomfortable. And so students really do have to, I think, use this as an opportunity to learn how to respond to that sort of thing, not just be shielded from it.
Professor O, would you care to respond?
I think the only thing I would add is about the whiteboard. I mean, I think schools could do it. It doesn't raise core First Amendment concerns. The question about is it a wise thing to do? I think that's an issue, and that's what schools always have to consider. Does it make a lot of sense? Are there other? I think schools, universities, colleges have to be very creative as a way and as possible in trying to deal with harassment, disruptive speech that can create a hostile environment. Okay, but try to be as creative in ways in doing so. Okay, and trying to respect all of the factors and values involved. It's tough, and it puts schools in a very tough decision, but that's, I think, the goal to strive for. And so sometimes something where it might technically not violate the First Amendment or doesn't really implicate core principles, question is whether it's a wise thing to do.
Mr. Reyes?
Thank you. In 2016, this campus faced controversy when a fraternity used sombreros in a politically charged skit. Following multiple letters in our campus newspaper and coverage by Cleveland's Plain Dealer, the university responded by imposing sanctions on the fraternity and requiring sensitivity training. Ms. Cruz, my question is, how can we distinguish between one's protected right to freedom of expression while also protecting others from unnecessary insults?
I think this is an issue where the solution comes from outside the realm of sanctions on these people who were throwing the party and potentially saying the insulting things. And I think it's important to remember too that when you punish people for things like this, it's not going to probably change their minds about anything. If anything, it might make them feel like sort of a martyr, and it's likely to not change what they do in private or what they say to other people in private. And really the answer to situations like this is to talk to them as much as you can like human beings and explain how, if it makes you feel a certain way, explain that, and not to just jump to punishment, which depending on where you are, either can be constitutionally prohibited or go against, as at Case Western, go against promises of free speech.
Okay. I think that is an example where what I was talking about it really implicates what I'm talking about, the hostile educational environment, where students do something that the reasonable minority perspective might perceive that as being racist or not just offensive, but harassing and harmful. Okay, and the problem, and this goes to the point you raised, that some of this speech is hard to categorize easily as hate speech. Okay, sometimes from the facts I understood, it wasn't absolutely clear that this was overt, is that right? Overtly, I guess you would say racist, but that it had connotations and implications. What do you do in that situation? From just a technical point of view, Case Western was completely legally within its bounds to do what it did in terms of sanctions and didn't have any First Amendment restrictions on what they did because as a private institution, they are not bound by the First Amendment. Okay, so they technically don't have to comply with the First Amendment in order to deal with those kinds of issues. They might have to deal with university policies, but that if they want to, they could have done. I think they were justified, legally justified in whatever sanctions they had imposed. But again, back to the question of, I think that's the question we want to think about, and taking the perspective of the minority group, which is, would this help promote a atmosphere that is hostile in terms of the learning environment, the inclusivity of the educational environment for racial minorities, and if there's a close call, given that there is no First Amendment real concerns with restrictions on what Case Western can do as a private institution, it doesn't seem like what Case Western did was inappropriate in terms of sanctions. I would say, though, especially if it's not so clear-cut, but they're clearly, it's more dealing with subtle racism rather than the overt kind. What do you do in that situation? Any kind of sanctions or punishment, I think the kind of sanctions or punishment should really aim to teach and educate rather than be purely punitive or mostly punitive in nature. As a way to try to teach people, here are some of the issues that people had with this, and here's why. Here's all the history implicated by what you did. I think sanctions are important in a situation like this because, again, back to what I said, it gives a message to students, to all students, that this kind of racially insensitive or potentially harmful speech can be harmful and won't be tolerated. And that going forward, maybe that the fraternity would take more further precautions in dealing with, in doing something similar, maybe get more diverse perspectives, okay, that they would be more proactive in making sure that what they did wasn't either offensive or could be offensive.
Thank you. Ms. Truth, do you care to respond?
Yeah, I think that it seems like there's probably a pretty substantial gray area where the determination of whether something qualifies as legal harassment is a really fact-specific determination, and we might disagree, but my analysis might also change if I had more specific facts about what was going on, and that's fine. But I do want to emphasize that the Office for Civil Rights, which enforces these civil rights statutes, has specifically said that schools should be careful not to infringe on freedom of speech when they're applying these civil rights laws. And it said even in the cases of private schools that aren't bound by the First Amendment, if they decide to punish protected speech, it's a decision they're making, but it is not something that the department was encouraging or even really approving of. So even coming again from the agency that's responsible for enforcing these civil rights laws, they also acknowledge that you have to be careful not to limit speech while targeting harassment.
Ms. Spangler?
Thank you. As many of you know, there has been a recent increase in protest directed at guest speakers on campuses. While some believe that blocking controversial speakers, such as Milo Yiannopoulos, is justified, others contend that such action constitutes viewpoint discrimination. Ms. Kruth, should students have a say on who speaks or does not speak on campus?
Well, the way that they have a say is that they can invite who they want, and if they don't like somebody who's being invited to campus, they can invite someone else who they do agree with to provide an additional viewpoint. I don't think that students should be able to, at least they shouldn't be able to successfully convince the administration to cancel an event, particularly at a public school. So generally speaking, I'm talking about public schools and private schools that promise freedom of expression. We do see a lot of successful calls for disinvitations, and it is within student rights to demand them. It's just that schools should not give in to them. At FIRE, we protect students' rights to ask for things that we do not want schools to actually give them, so that's part of it. They can demand it, but as soon as you start letting other people sort of veto everyone's invitations to outside speakers to talk, eventually, you know, no one but the most uncontroversial speakers are going to be able to talk. And actually, I say no one but the most uncontroversial speakers, but I heard that Mr. Rogers was disinvited somewhere. So, I mean, really, the limits are kind of endless in the downward spiral of disinvitation land, I think.
Professor O?
Well, again, with respect, I would make a distinction between private institutions and public institutions. Public institutions are bound by the First Amendment, and in some cases will have to allow for students to be able to invite speakers and can't censor or restrict their views, especially if there's issues dealing with a public forum, if the school has opened up a public forum for speakers. Private institutions, on the other hand, have choices, have a wider variety of choices, and they have to make a determination what values are most important in terms of who to invite to speak, and also with the recognition that who you invite to speak can reflect back on the institution and the institution's values. That must be considered in the equation. Okay, that if you have one school consistently allowing for certain kinds of speakers expressing certain kinds of views to come, then people might attribute, right, a government viewpoint with respect to government endorsement of such speech. Okay, and or the school's endorsement of such speech, and to the extent that it may not want to endorse or appear to endorse certain kinds of speech, I think especially private institutions should consider that in figuring out policies, general policies, to determine what kinds of speakers are allowed on campus.
Ms. Cruz?
I think that schools are actually making it harder on themselves by trying to exercise control over the people that students invite, because the more control they exert over student groups inviting outside speakers, the more people really will think that if they allow someone to speak, it's someone the school approves of. And if a school consistently just stands back and says, look, the students invited, whoever it is, all we do is sort of neutrally let them do that, it's a lot easier for them to distance themselves from these viewpoints that they don't agree with. It's a lot harder for them to do that once they start getting involved in actually making decisions about who can come.
All right, we have time for one more question from the panel. Ms. Atakabi.
Thanks. Ms. Kruth, in your recent article about trigger warnings and also in your opening statement, you mentioned that private institutions are not legally bound by the First Amendment. Since Case Western Reserve is a private institution, how, if at all, are Case students protected by the First Amendment?
Well, they're not protected by the First Amendment on campus, but I think that it's really important for Case students to demand that the school live up to its promise that students will have the ability to believe different things and express different beliefs. And that's really all we ask from private schools, is that they be upfront about what students are allowed to do and what they aren't allowed to do, so it's not sort of a false advertising situation.
Yeah, I mean, I agree with that. I think whatever policies, I think, well, first with respect to private institutions like Case, you have more negotiating room in terms of what policies you end up having with respect to speech. Okay, it's the notion that free speech requires policy X does not apply, okay? And with respect, the First Amendment does not apply with respect to private institution, which just means you have more choices in terms of and more discretion in terms of what policies you set forth. And my main point is that you should consider all values, not just free speech values, in making these kinds of decisions. Determine what your values are, weigh them, consider how important they are, invite students in, maybe to help into their discussion, to make decisions about the values of the school, and then set up policy that can be applied fairly, consistently, and clearly.
Do you have any last remarks on that?
I do not want to say anything after clarity. That's the bottom line.
Okay. So at this point, we can actually begin to move into the audience questions part. The only thing we ask is that you keep your questions as concise as possible and only ask one question at a time so that everyone who has a question can ask, and also to keep them respectful of the speakers as you have so far. And our ushers will have microphones coming down. Actually, I think Tim's a little closer, so we'll start here and then I'll come over there in a minute. Yes.
Hi, this is a question for Ms. Kruth. Milo Yiannopoulos has said that gays should get back in the closet. Being gay is abhorrent, and being gay is a lifestyle choice guaranteed to bring gay people pain and unhappiness. This speech is openly hostile towards specific groups, in this case, gay people. So this kind of speech would make gay people feel unwelcome on campus and make them feel unwelcome to express their views and opinions. So couldn't you say that protecting students' right to invite speakers would in some cases constitute a situation where other groups' speech is not being protected, in which case they feel unwelcome to share their views and opinions?
I think we have to treat college students like they are, to a large extent, strong enough to speak their minds, even if they think that people are gonna disagree with them or not like them. It's impossible for public debate to exist otherwise. And I understand that it's very hard to speak up in that circumstance, but Milo is a visitor. It's not the institution expressing hostility to gay students. And I think that we just need to, the school should be reaffirming everyone's rights to speak their mind, and that obviously includes gay students in this instance. I also think that to the extent that Milo helps students who agree with him sort of come out, I think at least we know who these people are that need to be convinced otherwise. I think it's a lot more dangerous to have people who agree with Milo, but at least as far as the homophobia, and not know who they are and never be able to talk to them or change their minds. There's actually several really great stories about people's minds being convinced on this topic that I tweeted out in advance because I knew it would come up. So if you go to my Twitter at Susan Kruth, there's stories about, for example, Derek Black, who used to be a white nationalist, and Megan Ropes-Roper from the Westboro Baptist Church. And I know that it is really hard, but I think that trying to change things that way is a longer lasting and better solution than just trying to keep people silent and not changing their minds.
Professor O, would you like to respond to that?
Yeah, I think that is a consideration where you have to think about the educational environment and the kind of speech it is in terms of value, or what I mentioned in terms of how socially useful are some of the things being said. And I suggest that they're not very socially useful, they have very low value, and that schools, especially private institutions, should weigh those concerns. And also the concerns that you laid out in making decisions, and it shouldn't automatically default towards free speech and neutrality. I think that's the default position we automatically revert to, and I'm suggesting, especially for private institutions, you shouldn't have to default to that. There are the concerns you're raising, especially with speech that really gets to the speech that attacks people for who they are, okay, where it's hard to rationally argue against that and try to use counter speech to fight against that, because it's irrational. It's based on irrational prejudices and bigotry. Okay, so in that case, I'm not sure how effective counter speech might be. Okay, and given all the concerns I read, especially in terms of school endorsing, people believing that schools endorsing certain kinds of speech, making sure there's an inclusive educational environment at that school, then the school should think hard about saying whether or not he should be able to speak, and especially if they have clear guidelines for saying, here's why you've met these guidelines, and here's these reasons why he doesn't merit being a speaker.
Mr. Ligg? Yes, just quickly.
Questions directed to Professor O. You mentioned that indicated there was no absolute free speech. My question to you is, it seems to be a didactic discursive prerogative when we talk about free speech. And there seems to be some nebulous issues around what is reasonable. My question to you is, if there's no absolute free speech, what are the elements of aggravated menacing, domestic violence, or assault in terms of that, which can be speech, it could be operating in a speech context? And what is reasonable, and what are the elements of that in this context that we're speaking of? Because it seems to me there seems to be an overlap when we talk about criminal menacing and aggravated menacing in speech, domestic violence in speech, or assault in speech. What is the overlap, and where's the intersection, and what is the ambiguity around reasonableness?
Well, there's a lot there. Well, I would say, in terms of reasonableness, what I had mentioned in terms of what a reasonable person in a particular perspective think of the speech or conduct as harassing in nature, creating a hostile work environment or hostile educational environment. There is no, reasonableness is one of the key concepts in law, okay? To determine whether a person has violated the law, we ask in terms of whether a reasonable person would have engaged in certain kinds of conduct or not. So the concept of reasonable person that I laid out, there are some, there's no clear-cut, rule regarding what's reasonable or not reasonable, but we use basically common sense and intuition based on history and context to figure out what's reasonable. Like the cases I mentioned, the courts have said in the context of the situation, a reasonable person would have found the use of the N-word against employees, referring to the employee as, as context, a reasonable person would find that to be an abusive environment. And I think that's a reasonable conclusion to draw. And the whole legal enterprise can only exist if we have notions of reasonableness. And that we can't just totally fly off and saying, well, we can't really determine what's reasonable, so we can't regulate anything. I don't think we need to go there. There's going to be tough calls, but sometimes there'll be easy calls, but that's just what law requires, dealing with these kinds of issues.
What about the second part, about the menacing, the assault, and domestic violence as an act of speech and the context of that? If there's no absolute free speech, can this be applied in these particular contexts and services in the academic or higher education, menacing, assault, or domestic violence, in terms of there's no absolute free speech?
All right.
Yeah, well, I'm not quite sure what you're asking, but I would say there's something called the speech conduct distinction in law. Okay. And there are things that, with assault, that fall clearly in the category of conduct, and that is that's clearly prescribable. There are no free speech protections for conduct. Sometimes the court says speech, the nature of speech rises to the level of conduct and therefore can't be prescribed. But I'm not sure that's a useful way to think about it, because on the bottom line, sometimes speech itself can be harassing, create a hostile environment, and speech itself then can be regulated, and it doesn't make sense to say it's conduct. But there is some, there are conduct. Yeah. Yeah, right, for conduct. If it's right, depending on the conduct that's being based, that you're using to make those determinations.
And in the interest of time, Ms. Kruth, I'll give you 2 minutes just to respond to that briefly, and then we'll move on to the next question.
Oh, I don't really have anything to add. I mean, I think that just briefly, I think it's important to err on the side of protecting speech when we're in these sort of gray areas. But as soon as someone is being physically touched or hurt, that just is a whole separate thing. And you can, I mean, it's outside the realm of my expertise, but that can be punished, same as what Professor O said.
Thank you. We have one question here, I believe.
The relevance of that last question is interesting because, Ms. Kruth, in your opening statement, you talked about the line between conduct and speech, but throughout this conversation, we've been using the phrase freedom of speech and freedom of expression in the context of college campuses somewhat interchangeably. So my question is, in 1989, the Supreme Court ruled in Texas v. Johnson that flag burning is protected under the First Amendment as a form of symbolic speech. My question is there a way to clarify the line between conduct and symbolic speech, or do we have to approach that issue strictly on a case-by-case basis?
I think there might be situations where you sort of have to look at the specifics. So, for example, in the flag burning instance, it's important to think about the fact that the reason why it was banned was because of the viewpoint. They weren't concerned about, fires catching and things like that. If a campus wants to say, don't burn things, it can do that, and that will end up also encompassing flag burning. But since it's based on sort of the content, viewpoint neutral ramifications of things burning, it's not, that would be a conduct restriction. If it was don't burn flags in order to protest things the government is doing, that would really be a viewpoint-based expressive restriction.
Great, Professor O. Sorry, one moment.
In terms of what's symbolic speech, it's important to note that the cross-burning case I mentioned, that was symbolic speech. And the key part is, does the act, its conduct that tries to convey a kind of a message, a viewpoint, a perspective. Once conduct does that, it becomes speech. Okay, and so with the Virginia versus Black case, what's interesting to note is that Justice Clarence Thomas actually tried to characterize cross-burning as conduct as a way to say that could be restricted, but the majority did not actually go there. Yeah, I said, this is symbolic speech, this is speech. And even as speech, because of its harmful nature, because it's based on the intent to intimidate, it can be restricted by the government.
All right, and our next question. I'll get you next, right here.
Hi there. I'm going to bring up something you talked about, that Mr. Ray's question about with the sombrero, and this is for you, Professor O. You seem to agree that the sanctions were necessary in that situation. Is that correct?
It was necessary. I think I said it was permissible. I don't know all the facts about what happened, but that there might have been reasons that they could have had reasons to justify what they did. Yeah.
Well, I thought what was interesting was that he brought up that it was like in the school newspaper several times. There was like conversation about what happened. Why do you think sanctions would solve that problem more so than just like students speaking back and like the marketplace of ideas? In what ways are sanctions solve the problem more than if we just speak more against it?
No, it's a good question. And I think I agree with, like, in most cases, counter speech is probably the best way to respond to something like this, and to say, as a way to educate people about why people thought that there was some problems with the play, okay, the musical. I think where sanctions becomes important is where it goes to how the school responds to incidents like this. If a school does, like, we'll give the more blatant example where there's students being subject to the N-word, okay? The school lets that happen and does nothing about it and is aware of it. What message does that send to students about how does school feel about this kind of situation conduct? And so to the extent that sanctions sends a message about what kind of environment is required in the school for it to be inclusive in nature, I think they have some merit and value. But again, I still think in terms of sanctions, especially when it deals with something a little bit more ambiguous, that sanctions that are really intended to promote education and learning are the best. So I think part of the sanctions, I don't know if correct me, involve training or diversity training with respect to those issues. I think that's a perfectly fine kind of sanction for that kind of speech.
Ms. Kruth?
I think the way that the school expresses its opinion about this should just be by it expressing its opinion, saying we do not agree with whatever is being portrayed, but without sanctions. And I also think that with sanctions for this sort of thing, there's also the risk that even more clearly protected speech is going to be chilled. And that is, I mean, that's potentially really detrimental to campus debate about all sorts of things.
Okay. Next question. Take Professor White down front.
If I understand Ms. Kruth's argument correctly, the problem with private schools like CWIU, to which you specifically referred, was that students would be misled by post-speech language in university documents. On the other hand, and you quoted such documents, but you also quoted two other statements from the university, which could be used to draw the conclusion, if one read all three of them, that there's a variety of values at stake, and so on. So, and you then doubled down on this argument later by referring to private schools that promise freedom of expression. So, question: A, what is your evidence that any prospective students have read said statements and therefore the first statement that you cited and therefore could be misled by it? And secondly, what is your evidence that they read that statement but not the other two?
Well, from the policies that I've seen, when private colleges do have these statements, they're usually more prominent than hidden restrictions on speech. They're at the beginning. They're in their big, broad principles governing the university. And so I do think that just from placement alone, it's much more likely that people are going to see those promises of free speech than some hidden posting policy or you know, buried into page 26 of the Code of Conduct. I don't really think that students are likely to read the entire Code of Conduct, but I do think that in flipping through a school's website, they're very likely to land on these broad principles that the school celebrates and displays prominently in many places on their website. So, I mean, I don't have numbers for you. Obviously, I can't do that. But the way that schools present this information is designed to get the good sounding stuff up in front where people see it and to hide the restrictions.
Professor O, so the question was really directed to Ms. Kruth, but do you have anything to say about posting policies, about the discrepancy between the two policies?
I don't have that much to say. The one thing, the two things that come to mind when you're talking is the concept of reliance and notice. How do students actually rely on the policies to think that certain kinds of conduct or behavior or speech is permissible, and then are they then do they rely on to their detriment if the school does something inconsistent with that policy? Is that kind of what you're saying? And so it goes to me, I think it really goes down to how well the students actually know about what the policies are. And like you said, I'm not sure how well the students actually do know that. I think if it's an important value and these regarding free speech and what kind of speech is appropriate is an important principle for the school, they should make it very clear about what are the free speech conduct guidelines for students, and to emphasize that so students are aware of what kind of speech is permissible on campus.
I think we have a question up in the back. Just use the mic because we're recording. Sorry,
okay.
Just a minute.
So we've been talking a lot about the protections that are relevant to students, but there's a large population, especially on this campus, that are graduate students that might be involved in instructor roles to a degree. And there's recently been an incident at the University of Nebraska-Lincoln, which is of course a public university, where a graduate student and lecturer was removed from her teaching position after protesting an undergraduate student who was recruiting for a conservative organization on the campus. And the safety issue, there were so many threats that the university decided it was a safety issue, and she was removed from her teaching, which has now potentially derailed her ability to graduate on time with her doctorate. And so just in general, I was wondering, what is the line? I mean, graduate students are students, but they're also in these authority positions in classrooms frequently, and their interactions can kind of cross with undergraduates in particular. So I was wondering if either of you had any thoughts about how graduate students should view themselves on these issues, if they have the same protections as undergraduates who don't find themselves in these kind of instructor roles.
Yeah, I can start. There are a lot of factors complicating that, as it seems like you can appreciate. One important thing is that public employees don't have, and that includes public school professors, don't have all the same rights, and the framework isn't exactly the same as students. But that being said, they still obviously retain a broad range of rights. And one factor that is likely to come into play in this sort of situation is whether the punishment affected her status as an employee or whether it affected her status as a student, and that's a really important distinction to make. It also, when they're trying to figure out whether to punish this person, they should be considering whether whatever they're objecting to was in the course of her performing her job duties or whether it was something outside. That said, the Supreme Court has sort of set aside the issue of whether there should be kind of more leeway for academic freedom than for other public employees doing their job. So, I mean, there's a lot going on and probably too much for answering this question, but those are some of the factors that should at least be considered in this situation.
So I just would add, it raises an academic freedom issue, which is different from what students, issues with regard to student speech. And to the extent her academic freedom was restricted by that, then there are First Amendment issues. And it's, even if she's a graduate student, I think if it's impinging on, was a reflection or was based on her teaching, is that what is based on the facts you're suggesting, then there are, I'm not sure whether or not there are First Amendment implications to that. And academic freedom is definitely, you know, as a professor, it's something that I think is extremely important, and that to have any interference with academic freedom is a core First Amendment issue that hopefully would favor the side in terms of protecting academic freedom.
All right, next question. Yes, right up in the back.
This question is directed for Ms. Kruth. So on the topic of universities disinviting speakers, much of the rhetoric was centered around speakers that were invited directly by students and student organizations, but obviously many speakers are invited with support from, or help and selection from, or direct funding from university departments and administrators. How does that affect the role that students should have in selecting the speakers that come to their campus?
I might have misheard you, but it seems, I guess, a little bit contradictory at the end of what you said. I think that students should be able to invite who they want. If a school invites someone and then, for example, bows to public pressure either from students or from outsiders to disinvite someone, it doesn't present the same sort of First Amendment issues as when they disinvite someone who was initially invited by a student group. But I think that it's something that we should sort of be wary of, just because anytime a school starts making those decisions based on public pressure, it's gonna create this environment where it incentivizes people to either threaten disruptions or just ask for disinvitations, and that increases the likelihood that somebody's First Amendment rights are going to be violated. And it also, like I said before, sort of just eventually narrows the pool of people who students are going to be hearing from until only non-controversial people are being invited to campus. So it is really important to look at who actually made the invitation in the first place as far as legal issues and constitutional issues, but I feel like either way, it should be sort of a red flag to students or just anyone in the community who wants to hear a wide variety of views.
I just would just say it's generally a good thing to have, a wide variety of speakers speaking on a different range of things, and to the extent that I think it's good students have choices in terms of who they get to bring on campus. And I think that is consistent with the mission of the school. And I think I think with students, though, the question is to also do it so responsibly, and not just think about the greater welfare of the campus, not just necessarily their particular interests, but in terms of what it means for all other communities on campus as well.
I'd actually like to draw this out just a little bit more, and then you can, of course, respond. Do you see a difference in setting? For example, this is a forum where we all are able to exchange, we can ask questions and debate this, but do you see a difference when someone is invited and that setting is very different, where it's only speaking and they leave, and that could be perceived as the position of the university at large?
And that's an interesting point in terms of in terms of the way the speech is set up, in terms of is it this kind of format? Are there other speakers? So, if you invite a controversial speaker, you might want to say, well, let's have someone else come and speak who might present a different kind of view. And it's interesting that at that Berkeley Free Speech Week I think it's this week or next week, that all the speakers are aligned on one side ideologically. That if you're really about free speech, it would seem like you would invite people with multiple points of view. That thought occurred to me. Yeah, I don't know if that answered your question.
Okay. Thank you. And do you have any response to that? Sorry.
No, I would just sort of what I said before. The school can take lots of strategies to make clear that they're not approving of the speech that comes from invited speakers from student groups. So.
Okay. Next question. We'll go here and then we'll go here and right down the aisle.
Several of my professors started this semester by saying that one of the guiding principles of a university should be a search for truth. I agree that truth can come from having diverse viewpoints on board, but when certain speakers are acting in bad faith, as many of the hot button speakers could be said to, as they advance themselves and their own careers off controversy, when they're acting in bad faith and not attempting to advance the search for truth, this question is addressed to Ms. Kruth, by the way, I'm sorry. When a speaker is not trying to advance the search for truth, is it appropriate for the university to refuse to host them on the grounds of their own mission?
I think the same principles that I was describing before apply. If it was a student group inviting them, they should, let the student group do its thing. I also, though, really liked, I forgot who it was who said this. It was a professor in California who encouraged people to, especially if you disagree with someone or you think that they're just, spouting BS, he said, listen, question, and embarrass, or something to that effect. And I think that's a completely legitimate and great tactic to use. If someone is not, speaking in good faith or arguing in good faith, go up and make that clear to everyone so they're outed as someone who is not actually engaging in good faith or not saying accurate things or whatever it is that you're objecting to. A lot of the times it's not even that hard to make them look like fools, and that is obviously something that's allowed, and I would encourage people to do that in these cases if they, have the time. I assume somebody has the time to do that. So, you can't do it every time, but I think that it helps when people do choose that route.
I think Professor Moore, were you the next in line? I'm sorry.
So I want to ask about a slightly different aspect to this, in which academic freedom and free speech, I think, are entwined. And it's about the issue of off-campus intimidation of both faculty and student speech. The most prominent examples today across the country happened on our campus last year. So we had a student group that showed a movie available in the library that critically examined the politics around Israeli public relations in the United States. As a result of that, there was engagement on the campus. Students were engaging each other. There were articles in the student newspaper which is good. But it didn't stop there. We had a local newspaper cover it, in which an official at a very prominent community organization said, quote, "We're going to monitor what's happening on campus." Didn't stop there. There are 3 well-funded websites that operate in the United States with a goal to, in their view, outing anti-Israeli, what they consider anti-Semitic speech. Our student organization appeared on one of those websites, tying their activities to what this website deemed to be the anti-Semitism of a movie available through our library. So, and there are multiple cases of this across the United States, also involving faculty that have been denied tenure, more recently at San Jose State, where an endowed chair was pulled by the university. So my question is, how can universities, public or private, protect our students so that they're not intimidated? Because you can't imagine, clearly they're adults, but they're also worried about their careers. And if their names are attached to this on some sort of website, doesn't the university have a responsibility somehow to protect our students so that they're not intimidated to make political voice, even if it's controversial?
That's really interesting, and I think you're right that's a situation where schools can step in and do something about it. That they do have they might have feel responsibility over protecting its students, and in that situation where it seems like outside speech could be in some way inhibiting speech on campus and speech by students, I think schools should have responsibility to do what it can to protect students and protect their speech. In terms of the issues regarding academic freedom, I mean that's a tough one, and the blurring between the lines of what is done on campus and on the classroom and outside of it, and to what extent does what you do outside matter in terms of what you can do inside on campus? Those are really tough questions. The thing that I don't know if this is somewhat a little bit different, but there was that a professor at University of Florida or Tampa who tweeted about the hurricane and said something offensive and was fired as a result for a tweet. And it was a private campus, so there were he didn't have any First Amendment protections. So especially with the internet, you got those issues about speech that takes place off campus and its relevance to speech issues, student rights on campus.
Ms. Kruth, would you care to respond?
Yeah, I mean, the situation you described is really tough. I think it's part of the reason why it's really dangerous when we start demanding that people get fired for things they say. But I also think that one of the most important things that the school can do is train students to defend themselves persuasively. It's really hard when that is necessary, especially when someone is, potentially making unfounded attacks. And especially when students know that they're about to start their career and that might be in danger. But ultimately, one of the main purposes of the university is teaching people how to be persuasive and point out flaws in what other people are saying and debate. And I think that is a really important tool in this sort of situation.
So unfortunately, we are out of time for further questions, but the speakers will both be upstairs afterwards to answer any questions that remain. So we will now proceed with the closing statements. Each speaker will have 5 minutes, and since Ms. Kruth began, we will have Professor O begin at the end here.
Yeah, I'm not going to use up all my 5 minutes, I'm pretty sure.
Okay.
I think just from what we've talked, obviously I think we all agree about the importance of free speech, whether it's on public campuses and also on private campuses, even though obviously the First Amendment doesn't apply to schools like Case Western. It's the principles and values, we all agree, those are core quintessential American values, right? The right to free speech. I think though, and this applies I think to both public and private institutions, that I mentioned this earlier, is that we don't necessarily default to First Amendment neutrality as the policy answer to tough questions. That there are other competing principles that are just as important, also mandated by the Constitution, and therefore those factors and considerations must be considered as well in deciding issues regarding, what kind of, of offensive play, for example, how the school should respond. So less focus on absolutism and focusing on the core, really thinking hard about the core values and principles that are involved, and not beyond just the First Amendment, but principles about inclusion, equality, inclusion and equality. What I also want to say, and just to reemphasize, I think schools have a legal, not just that they should, but they have a legal duty to provide for an inclusive learning environment, especially with respect to race and gender, okay? And so this is where schools have, it's a tough call, right? They have, on the one hand, free speech principles to deal with, and on the other hand, principles of equality to have to deal with. But you just got to do it. You got to weigh those considerations and do the best you can in terms of protecting those values. I would say, though, with respect to private institutions, if there's a close call, that because there is no First Amendment actual principle applying to private institutions, that also has to be weighed in when making these kinds of decisions. There's a lot more freedom with private institutions to deal with these issues, and I think in some ways schools may want to shy away from that freedom and just fall back onto, oh, okay, free speech prevents us from doing anything about it. And I just want to suggest that, do the hard thing and really grapple with the core issues and values that are at stake in some of these issues. Yeah, I think that's it.
Ms. Pruitt.
I also am probably not going to use 5 minutes. I just think it's really important to remember that free speech isn't just a constitutional issue, it's really a broader principle, and all the benefits of open and vigorous debate and all the dangers of censorship are applicable whether you're at a private school or a public school. I think that it's important to err on the side of allowing more speech because speech is fundamental to everything. If we can't have open conversations, we're not going to make progress on anything, no matter how you describe progress, whether that's equality and inclusiveness or something else. You simply cannot have progress without speech. And I've seen too many situations that I wish I had more time to talk about where policies that were in place to either meant to address these civil rights issues or otherwise were supposed to help people feel more inclusive ended up being applied against the exact people that the policies were supposed to be protecting. And it's really tragic that that happens, but the way that we can protect against it is by having, if there are speech restrictive policies, having them be specific and clear and narrow so that they don't run the risk of shutting down expression, which is really the best avenue for positive change.
And Ms. Holmberg will proceed with the closing statements on behalf of the committee, but I'd personally like to thank everyone for being so cordial and welcoming of our speakers today. I hope this dialogue will continue because it is extremely important for our democracy. Ms. Holmberg.
The Constitution Day Student Committee would like to express our most sincere appreciation to Ms. Kruth and Professor O for joining us today. We would also... We also give special thanks to the Office of the President and the Provost. As many are aware, this is Provost Bazelak's last year as the Provost at Case Western Reserve. So we would like to thank you for your decade of service to the university in this role. We would also like to thank our many contributors for this forum, so please hold your applause until the very end. The Office of Government and Community Relations, the School of Law, the Department of Political Science, the Center for Policy Studies, the Case Western Reserve University chapter of the Federalist Society, our student panelists, moderator, timers, ushers, and other volunteers, and our wonderful advisors, Professor Laura Tartikoff, Dr. Lucker, Professor White, Dr. Dole, and Dr. DeSwart. At this time, everyone is invited to proceed upstairs to the Black Acre Lounge, where refreshments will be served. Ms. Kruth and Professor O will join us upstairs to answer any questions that remain. Thank you.
Relevant than they've ever been. I want to first make sure we're all on the same page as far as what the First Amendment protects, broadly speaking, and then I'll talk a little bit about why we don't punish more speech and what we can do instead of punishing speech. The vast majority of speech is protected by the First Amendment. There are just a handful of categories of speech that are unprotected, things like true threats, obscenity, incitement to imminent lawless action. Those are not protected, but it's important to remember that these each have legal definitions that are much narrower than the way that we use these words colloquially speaking a lot of the time. Now, you'll hear people argue that there's a line between hate speech and free speech. In the US, there isn't. There's no legal definition of hate speech because, in the United States at least, because it's not one of the unprotected categories of speech like true threats and incitement. And some of what somebody might call hate speech might rise to the level of true threats or incitement, and in that case it would be unprotected, but most of it does not rise to that level, and so it's still protected even if it's offensive or hateful. And part of why we don't prohibit hate speech broadly is because people wildly disagree about what would qualify as hate speech. Just the other day, for example, Donald Trump Jr. tweeted, if it's hate speech to call someone by the wrong pronoun, then it should be hate speech for somebody to burn the flag. Or for another example, maybe you think that the Westboro Baptist Church's signs that say God hates fags are hate speech, but maybe somebody else thinks that the way that you talk about the Westboro Baptist Church is hate speech too. And if Americans can't come close to agreeing what qualifies as hate speech among ourselves, then it's never going to be safe for us to trust the government or some higher authority to make that decision and to censor and punish people accordingly. So in most cases, with the vast majority of speech, you cannot be punished by the government just for what you're saying or censored. And since public colleges and universities are instrumentalities of the government, on public college campuses, you have pretty much this
changing facts and ideas. But recently, colleges find themselves on the front lines of unrest and discord. In wake of the violence at Middlebury College and UC Berkeley in the past year, is it necessary to ban controversial speakers from campus? 5 states say no. North Carolina, Tennessee, Utah, and Virginia have passed laws to prevent administrators from canceling speakers invited by students or faculty. The laws require universities to remain neutral in public controversies and to sanction students who interfere with the free speech rights of others. Moreover, the violence in Charlottesville has prompted public outcry and a new discussion on free expression's role on campus. Civil discourse is in a grave state. A recent clash at Berkeley resulted in the near-fatal beating of a protester. Innocent demonstrators were injured and killed when that car plowed through the crowd in Charlottesville. Given these realities, are there sensible limits to free speech that colleges should impose? Now, before we begin, please take a moment to check your cell phones. Professor O and Ms. Kruth, you will each have 10 minutes for your opening statements. Ms. Kruth, the floor is yours.
Thank you. Thank you to Case Western and to the Constitution Day Student Committee for having me here today. I wasn't sure if it was going to be harder to do a panel on free speech in light of the tragedy in Charlottesville and other instances where protests have turned into violence and vandalism on campus. But legally, the rules are the same as they've been for decades, and practically speaking, the reasons why we have such stringent protections for freedom of expression are more relevant to the same free speech rights that you have just out and about in the real world. The school might have measures in place just to make sure that the functioning of the university can continue uninterrupted, but it can't punish you for saying something that it doesn't like based on viewpoint, or for just handing out literature peacefully on the quad, although depressingly, a lot of colleges have tried to do this anyway, even though it's prohibited under the Constitution. I'm sure a lot of you guys are thinking right now, well, Case Western is a private school, and private schools are not bound by the First Amendment. If they want to, they can prohibit certain types of speech, even based on viewpoint. But what they can't do is promise students and professors the same freedom of expression that they would have at a public school, and then turn around and censor students or punish them for their viewpoints. A few private colleges are really upfront about the fact that they prioritize other values like religion or civility over freedom of expression, and that's fine. For example, a lot of, BYU, I think Vassar does this, but the vast majority of private colleges and universities around the country do promise their students and professors freedom of expression, and Case Western is one of those private colleges that does that. So for example, Case Western says in its policies, universities seek to preserve, disseminate, and advance knowledge. As CWRU, as elsewhere, we recognize that to fulfill these purposes requires a norm of expected conduct shared by all in the university community, governed by truthfulness, openness to new ideas, and consideration for the individual rights of others, including the right to hold and express opinions different from our own. So a prospective student reading this could reasonably expect to be able to speak his or her mind on campus once they get here, similarly to how they would be able to express themselves on a public college campus. And Case Western enjoys all the benefits of applicants believing this and being attracted to this campus. But the university also has a policy, for example, prohibiting posting offensive language. And that could be almost anything.
A senior program officer from the Foundation for Individual Rights in Education, known by its acronym FIRE. FIRE is a leading nonprofit that defends and sustains individual rights at America's colleges and universities. We also welcome Professor Reginald O. Professor O is a renowned speaker on legal issues in education and a professor of law at Cleveland Marshall College of Law at Cleveland State University. The Constitution Day Student Committee is grateful that you have accepted our invitation to speak and to answer questions from our panelists and audience. Universities that foster reasoned and thoughtful debate are vital to a thriving society. This forum will address the extent to which speech can or should be regulated on a college campus. Can universities balance freedom of expression and the need for campus safety? What, if any, restrictions can be placed on student expression at a private institution? We look forward to hearing the perspectives that the two speakers will present according to their understanding of the United States Constitution. Now allow me to introduce our panelists. Ms. Coco Itakabe, Mr. Santiago Reyes, Ms. Amanda Spangler. Finally, please join me in welcoming the moderator for today's forum, Mr. Jacob Sandstrom.
Thank you. Ladies and gentlemen, in 1791, Congress amended the Constitution to safeguard essential freedoms. Recognizing the realities of human nature, our founders put the freedoms to worship, speak, publish, assemble, and petition at the heart of the First Amendment. College campuses have long been havens for free expression, allowing students to pursue wisdom by exchanging
Let me welcome you to our 2017 Constitution Day. I'm Bud Bazelak, the provost here at Case Western Reserve University. It's an exciting day. This is, I think, my 10th time I've been at Constitution Day, and I learn a lot every time we have these sessions. I appreciate everybody who's here. I know I've got to keep this timely, and I'll just really begin by just thanking everybody, thanking our guest speakers. Look forward to hearing from you. Thank you for the student organizing committee, all the hard work you put in. You know, some of you involved with this event multiple years. And I look forward to hearing the questions that you're going to bring. Certainly the faculty advisors, in particular Professor Lucker and Tartikoff, for all the work you've done in preparing the students and preparing for this event. This is really, you know, in terms of freedom of expression on college campuses, a very timely conversation, a very timely topic today. It seems like every morning when I open up my email, I get some announcement from the campus. Today was University of Chicago announcing their freedom of expression day or event or week. And this is obviously a very critical issue today. You know, it's interesting, over the years, the topics we've had at the Constitution Day events here always are very timely. You know, they connect to something that's going on either across campuses or across certainly the country. This one, I think, of all the 10 that I've been involved in, is probably the most timely. It's a complex issue. It's a challenging issue. I think as we're here today to learn, I mean, it will be, the key to making it work on this critical First Amendment topic is communication, understanding, and I think amongst all of us, and that's why we're really here today to do that. So with that, I will introduce our MC, Kelsey Holmberg, who's, again, this is your third year doing this, so welcome to that.
Thank you, Provost Bazelak. We appreciate your presence and support at this event over your many years at Case Western Reserve University. Good afternoon, distinguished guests, faculty, students, and friends. I am Kelsey Holmberg, and I am the Mistress of Ceremonies for today's event. The purpose of today's event is to celebrate the 230th anniversary of our founding charter, the United States Constitution. It is an honor to welcome Ms. Susan Cruz,